Hello students, welcome to our polity class series. In this class, we will discuss about the part 10th of Indian Constitution. In previous class, we have discussed part 9th of Indian Constitution where we have discussed the rural panchayat under part 9th, the municipalities for urban panchayat under part 9th A, and the cooperative societies under part 9th B. Now our next topic is part 10th of Indian Constitution, which deal the schedule and the tribal areas of India. The part 9th encompassing article 244 to 244A, and the title of the part 10th of Indian Constitution is the schedule and the tribal areas. So let's understand the structure, the administration of the schedule and tribal areas under part 10th of Indian Constitution. So there are two articles we have to discuss, only article 244 and article 244A. In this class we will discuss part 10th and part 11th both combinedly. So now first topic is part 10th and the second topic will be part 11th. So what does article 244 says? Article 244 explain about the administration of the scheduled areas and the scheduled tribal areas. Okay, in India, it is basically required to promote the scheduled areas as well as the tribal areas and the scheduled caste and the tribal caste. That's why this part was added during the time of formation of constitution in India. And mostly this part explain about the administration or proper function of the northeast scheduled and tribal areas. So article 244 explain the administration of scheduled areas and the tribal areas. So this article provides for the administration of the certain areas designated as scheduled areas and the scheduled tribes. It also includes provision for the establishment of the autonomous council and the regulation of law applicable to these areas. Mean article 244 also explains sub council, or it is talking about the establishment of some council or some regulatory body which will work for the regulation and formation of law for the scheduled caste and tribal areas. Also, this article is divided into two parts, the clause 1 of article 244 and clause 2 of article 244. As the title is the schedule and the tribal areas, so article 244 clause 1 explain about the schedule areas and article 244 clause 2 explain about the tribal areas. So what is clause 1? Basically clause 1, the provision of the 5th schedule shall apply to the administration and control of the scheduled areas and scheduled tribes in any state other than Assam, Meghalaya, Tripura and Mizoram. Okay, if there basically in schedule we will discuss the 5th schedule and 6th schedule. In 5th schedule it is explaining about the scheduled areas administration in the India. And in 6th schedule, it is explain about the tribal areas administration in India for the special state of the Assam, Meghalaya, Tripura and Mizoram. So article 244 clause A explain the 5th schedule of Indian Constitution, which is related to the administration and control of scheduled area and scheduled tribal areas in the state except Assam, Meghalaya, Tripura and Mizoram, because the administration of Assam, Meghalaya, Tripura and Mizoram is mentioned in 6th schedule. So now you are able to understand what is the difference between article 244 clause 1 and clause 2 or schedule 5th and schedule 6. Schedule 6 explain the tribals and the schedule areas administration and control all over India except Assam, Meghalaya, Tripura and Mizoram state. So a part of these 4 states, all state administration will be run according to the schedule 5th or article 244 clause 1. But article 244 clause 2 or 6th schedule explain about the administration of the tribal areas in Assam, Meghalaya, Tripura and Mizoram. So part 10th, article 244. Now next is article 244A. what does meaning A, B, C? If there is any alphabet number is added with any article, this means the article is added or the part is added after the amendment. So 244A article explain basically explain about the status of the autonomous state and the tribal state. This article, first we have to understand in which amendment article 244A added. So article 244A is added through 22nd Constitutional Amendment Act 1969. The 244 they added under which amendment? Under 22nd Amendment 1969. Clear? Okay. What does Article 244A say? It's explain about the formation of autonomous state comprising certain tribal area in Assam and creation of the local legislature or council of minister or both in the Assam area. Okay, let's understand the Article 244A. This article provides for the creation of an autonomous state within the state of Assam. So what does Article 244A said? It's generally provide the autonomous state with the or the creation of the autonomous state with the Assam. In Assam, it was also explaining the comprising of any of the tribal areas specifically in the part 1 of the table of graph 20 of 6th schedule. We will discuss the part 1 and the graph 20 of the 6th schedule. It allows for the establishment of local legislature and the council of minister for autonomous state. Before 1969, Assam was not an autonomous state. This state was directly controlled by the central government of India. After this amendment, when Article 244A added, Assam was created as an autonomous state with a local legislature and council of ministers. Here are two clauses, clause 1 and clause 2. What does clause 1 says? Clause 1, notwithstanding anything in the constitution, parliament may be law formed within the state of Assam, an autonomous state all or any of the tribal areas specified in part 1 of 6th schedule and create a body whether elected or partially nominated, partially elected to function as a legislature for autonomous state or provide that there shall be a council of minister or both with such constitutional power and function in each any case. This is specified within the law. Means the clause 1 is same explain that Assam is a autonomous state. All the specific areas of the Assam which are mentioned in the part 1 and paragraph 20 of the 6th schedule will basically take all the eligibilities criteria and there will a body will be created there to regulate this tribal areas, whether a body can be elected or can be nominated or can be partially elected or can be functioned by the legislature. And also there will be a legislative assembly as well as council of minister will be established in the Assam. The clause 1 is explain only about the Assam, means there will be a committee, in the simple term there will be a committee who will work for the scheduled tribal areas of the Assam and scheduled caste areas of the Assam which are mentioned in the 6th schedule. And also there will be a local state legislature with a council of minister. What does clause 2 explain? It explains that if any such law as is refers to in clause 1, if there is any law which is refers to in clause 1, particularly provided for like the distribution of the legislative power between the state of Assam and the autonomous state. Also, matter with respect to which the autonomous legislative may make laws and the extent to which the law made by the legislature of the state of Assam shall apply to the autonomous state also. The administration of the justice, the revenue and finance of the autonomous state and any other matters related to a connecting with the above mentioned purpose. So clause 2 explain about the powers distribution of the legislative power between the state of Assam and the autonomous state. It also explain about that if there is any law which are made by the legislative assembly, then it will applicable to the state of the Assam autonomous state. Also, it's also explain the administration of the justice for the state of Assam and also autonomous state and the distribution of the revenue and the finance. Clear? So this is part 10th of Indian Constitution, which explain the schedule and the tribal areas under Article 244 to 244A. Under Article 244, we have discussed that is explain all the schedule and tribal areas which is mentioned in the 5th and 6th schedule. The clause first of 244 explain about the fifth schedule tribal areas and sixth about explain about the to close to explain about the sixth schedule of tribal areas where is the administration are mentioned for only specific Assam, Meghalaya, Tripura and Mizoram state. 244A formation of an autonomous state basically, and it is only talking about the Assam. Clear? This is part 11, part 10th of Indian Constitution. Now in this class we will next discuss part 11 of Indian Constitution. So let's see the part 11 of Indian Constitution. So this is part 11 of Indian Constitution. What is the title of part 11 of Indian Constitution? Basically, the title of the part 11 of Indian Constitution is Relation between the Union and the Center. So this 11th part of Indian Constitution explain about the what are the relation between the Union of the India and State of India. As we already discussed, there is a federal system in India. In federal system, the powers are divided between state and center only. If there is a division of power between state and center, there must be a dispute between state and center. So it's this part basically try to resolve the disputes between a state and center. It clearly explain the power between state and center and also explain the relation between the union and the state. And the articles include from 245 to 263. So Article 245 to 263 explain the part 11 of Indian Constitution, which explain the relation between the union and the state. So this part outlines the distribution of legislative and administrative power between the union and the center. So it's clearly explained what is the legislative power for the state, what are the legislative power for the center, what is the administrative power for the state, and what are the administrative power for the union government. Clear? Okay. So let's start part 11th of Indian Constitution, relation between the union and the center, and the under part 11th of Indian Constitution, chapter 1 is legislative relation. The chapter 1 of part 11th explain about the relation between state and center government and what type of relation it is explaining. It is explaining the legislative relation between state and the center government. Okay. So let's start with Article 245. Article 245 extent of law made by Parliament and by the legislature of the state. What does it mean? It means Article 245 explain that for which part the Parliament can make law in the country and for which part of the state a state legislature can form law, or the law made by the Parliament cannot be rejected by the state. So basically, Article 245 says the provision of the Constitution, Parliament make law for the whole or any part of the territory of India. So what does Article 245 explain? The Parliament power, then for which part Parliament can make law. And according to this, the Parliament can make law for the whole part of the India as well as any particular part of the India. And it's also explained that legislature of a state can make law for the whole or any part of the state. So Parliament can make law for the whole part of India and state can make law for the whole part of the particular state. It also explained that no law made by Parliament shall be deemed to be invalid. If there is a law which is made by the Parliament, it shall not be deemed to be invalid on the ground that it would have extraterritorial operations. Clear? Okay. Next is Article 246. it also explains basically subject matter of laws made by the parliament and the legislature of the state. Means what are the subject and what are the matter of the law for parliament as well as state legislature. The first point says that parliament can make law for those particular areas or for on those particular powers. Into 245, we have understand that parliament can make law for state and center, and state can make law for the legislature for the state. In this particular article 246, it is explaining that in on which subject can parliament and state make law. So the first clause of Article 246 says that Parliament can make law on those subjects which are the part of Union List 1, which is mentioned in 7th schedule. 7th schedule. In 7th schedule, there are three lists explaining the Union List, the State List, and the Concurrent List. Union List. In Union List, the matters are added on which a parliament can make law, and state list explain the work of the state through which or on which subject can a state make law, and the concurrent list explain that on which subject both state and center can make law. So under 7th schedule there are three lists: union, state, and concurrent list. The subject which are part of union list, by on these topics union can make laws. The mention which subject are mentioned in state list, the state can make law, and for concurrent list subject both state and union can make law. So first clause says that parliament has exclusive power to make laws for the subject which are mentioned in list 1. List 1 means union list in the 7th schedule. Same, state can make laws for those topics which are mentioned in the list 2nd or the state list of the 7th schedule. Both parliament and state can make law with respect to any of the matters which are mentioned in the concurrent list. So for first list, parliament can make law. For second list, state can make law, and for third list, both can make law. Parliament has the power to make law with respect to any matter of any part of the territory of India, not including in a state, notwithstanding that such matter in matters enumerated in state list. The part of a state list matter, Parliament can also make law for the state also. Okay, Article 246A. Article 246A explain about the special provision with respect to goods and service tax with respect to the GST. So who can make law? Basic now any content contained in Article 246 to 245, Parliament, and subject to Clause 2, the legislature of every state has power to make law with respect to goods and service tax imposed by the union or by the such state. Parliament has exclusive power to make law with respect to goods and service tax where the supply of goods or service or both take place in course of interstate trade or commerce also. What is Article 247? The Article 247 explains the power of a parliament through which parliament can establish certain additional code. So in this, parliament may by law provide for the establishment of any additional code for the better administration of law made by the parliament, or if there is any pre-existing law with respect to the matters under union list. To basically enforce the union list matter or to for better administration, parliament has power. He can establish certain additional codes. 248 explain the residual power of the legislature. The clause 1 said that parliament has exclusive power to make any law with respect to any matters which are not mentioned in concurrently, which are not enumerated in the concurrent or state list. Such power shall include the power of making any law imposing a tax not mentioned in either of those lists. Okay, next question is Article 249 explain the power of a parliament to legislature with respect to a matter in the stateless and national interest. Let's suppose if there is a topic which is explained in article list 2 of schedule 7th, means through this topic only state can make law, but for some cases parliament has also right, he can make law for the list for if it is for the national interest. So if the Council of States means Rajya Sabha has declared by resolution supported by not less than two-thirds of the members present and voting that is necessary or expanding in national interest, that Parliament should make law with respect to any matters which is mentioned in the state list, it shall be lawful for the Parliament. Okay. So it is saying that if there is a topic through which only state government has power, means if the topic is mentioned under state list on or state list, mean for that topic only state can make law, but constitution also provide the power to the parliament that if it is for the national interest, parliament can also make law for the state list topic. But to make the law, first the Council of State Rajya Sabha has passed a resolution by 2/3 of majority, and Rajya Sabha has to explain that it is necessary to the make law for a state subject for national interest. For that case only Parliament can make law for basically the second list of 7 schedule. Clear? Article 250. What does Article 250 explain? Article 250 explain the power of the Parliament to legislature with respect to any matters in a state list if a proclamation of emergency is in operation. The simple meaning is that if there is a subtopic which is related to the state list, and if there is a national emergency in India, at that situation also Parliament can make law for that subject or related to that subject, which is the matter of the state only. The Parliament can also make law for state list subject if there is a national emergency in India. In previous slides, we have discussed if the law is for national interest and Rajya Sabha has passed a resolution by 2/3 majority, then Parliament can make law for state subject. And if there is a national emergency in India, at that situation, Parliament can make a law also. The Parliament shall, while a proclamation of an emergency is in operation, has power to make law for whole or any part of territory of India with respect to any of the matter enumerated in the state list. A law made by Parliament, which Parliament would not, but for the issue of a proclamation of emergency, has been compelled to make shall to extent of the incompetency cease to have effect on the expiration of a period of 6 months after the proclamation has ceased to operate. Article 251, it explains if inconsistency between law made by the parliament under Article 249 and 250 and law made by the legislature of the state. Okay, the question said that nothing in Article 249 and 250 shall restrict the power of the legislature of a state to make any law which under the constitution it has power to make. Means if parliament is make law for a state subject and using Article 249 or 250, this does not mean that a state cannot make law for this subject also. A state also can make law and parliament can also make law. Power of parliament to legislature for 2 or more state by consent and adopting of such legislature by any other state. Okay, the question says that, or the Article 250 says that, let's suppose if there is a law related to 2 or more than 2 states. The law is related to the state only, but this is the matter related to 2 or more states at that time. Parliament can also make law for state subject or related to state subject. 253 explain that legislature have given the effect to international agreement. If there is an international agreement, Parliament has power to make any law for the whole or any part of India for implementing any treaty, any agreement, or any convention with any country or other country. Decision made an international conference, association, or other body. If Parliament has make any agreement with another country, then Parliament has power. He can basically make law to implement this treaty or agreement for whole the country. Okay, the question next, Article 254 explain the inconsistency between law made by the Parliament and law made by the legislature of the state. So it is said if there is a law made by the state is repugnant to any provision of law made by the Parliament which Parliament is compelled to enact, or to any provision of an existing law with respect to one of the matter enumerated in the concurrent list, then subject to the provision of clause the law made by the Parliament, whether passed before or after passed by the state legislature, then Parliament has power. He can basically declare the law as a void. Means if the law is made by Parliament and legislature for them this particular state, then Parliament has power. He can declare the state law as a void. Okay, 255 explain about the requirement as to recommendation and previous sanctions to be regarded as matter of procedure only. Means for any act or for any law which is previously sanction required by the Constitution was not given, then the assent is required. Whether the recommendation required was that of the governor or either governor or the president, or recommendation required whether for the Raj Pramukh, either by the Raj Pramukh or the president, and previous section was that of the president or by the president. Chapter 2 explain about the administrative relations of the state, through which Article 256 explain the obligation of state and the union. 257 explain the control of the union over state in certain cases. If there is a case, certain cases, then the center can be control the complete state. Clear? 257A assistant to state by deploy of armed force or other force of the union, but it was laterly repealed by the constitutional amendment, 44th Constitutional Amendment Act 1978. 258 explain the jurisdiction of the union in relation to territory outside India. To develop the relation outside the India, it is a jurisdiction of the Union Government of India. 261 explain the public acts record and judicial procedure. 262 explain the education of the dispute relation to water or interstate, river or river valleys. If there is a dispute between river and river valleys, then the central government can make law for these two states also. And 263 explain the provision with respect to an interstate council. Clear? So this is the topic we have discussed, the part 11 of Indian Constitution, which explain the relation between the union and the state. In this class, we have discussed the legislative relations as well as the administrative relations between the union and the state. So I hope you understand this session. Thank you.